Good afternoon, Senator Branning. Thank you. We can begin now. All right, thank you. Gonna call the Judiciary A Committee to order. We're gonna start at the top and work our way down. And first bill is gonna be House Bill number 1088. You have before you, this came to us from the House, obviously, in dealing with our civil commitment process. And you have before you a strike all, and at the request of the Department of Mental Health, the strike all, the only difference from the House bill and the strike all is that we've replaced language back in there at lines, let's see. I'll let it, lines 22 to 25. And what the bill, as y'all know, we have been dealing with the civil commitment process, and what this is doing, if you particularly look at lines on the strike all, lines 29, circuit court shall retain jurisdiction and proceed with civil commitment. The bottom line on this is that what is happening is the circuit court doesn't have jurisdiction at this under current law to do the civil commitment process. It then gets sent over to Chancery. It then gets lost in the system, so to speak. I've also been advised by the Department of Mental Health that the forensic bed, they're working on the forensic beds. And so what this will do is allow the circuit judges to have that power to begin the civil commitment process. And with that, and bring up any questions. Senator Boyd.
Presently, right now, if the circuit court is not presently doing this, when they discuss this with you, if there are plans with, to do some education, some CLEs so that the circuit court can become.
There's training mentioned in the bill, yes.
Okay. Because I would have great concern without significant training on this issue.
And I just saw it.
I see it 152 to 154.
Yes.
Okay. All right. Thank you.
If the Department of Mental Health will provide that. Senator DeBar.
So thank you, Mr. Chairman. I mean, presently, most counties will have a special master to handle all these commitment hearings. Is that going to change? Or I guess will circuit courts relegate or I guess defer to the special master? Is that something that can just come out in a policy, I guess, based on the circuit district?
Based on my knowledge, there's nothing in here providing for a special master or anything within the circuit court, but I don't see why they couldn't do that.
And then if there is a special master, they can report to the chancellor or the circuit as the case may be, depending on where it's deferred from. Okay. Thank you, Mr. Chairman.
Senator Hobson.
Thank you, Mr. Chairman. My questions do follow in line with the previous ones about the removal. Well, let me ask this first. Who's proposing the change? Is there a group? Is it any of the chancellors or the circuit court judges that are proposing a change?
Yes and yes, and the Department of Mental Health is in agreement with this bill. Oh, and we have the Department of Mental Health here, and they're welcome.
Mr. Chairman, my recollection is that, I don't know, 4, 5, 6, 7 years ago, whatever it was, is that this was changed because the problem was the courts were saying that civil courts are not, circuit courts, excuse me, are not equipped to be able to handle commitments. So we're, and I think the idea then was let's get them over to Chancery courts where they're trained, they know what they're doing, and they can handle commitments. I don't know why things are getting lost in the process or lost in the system. But I do have concerns about circuit courts being better equipped to handle commitments than Chancery courts. And do you have, so would you not agree, as Senator Bryan says frequently?
Somewhat would agree in the sense that what you've laid out, but we've been working, if you combine this with the other bill that we've been working on this session, I think that clears those things up. In terms of, well, one, that's why we're having training, that the Department of Mental Health is doing the training. Two, again, the reality is people with these charges and all, they're being lost in the system and they're sitting there for a long time without being addressed. And if we did do that previously, it's not working.
Could we not have the circuit courts provide some order to the chancery courts requiring an expedited hearing or commitment process to determine if the person is qualified to, I guess it's to stand trial or to be able to pursue even a civil claim?
You know what? I'm going to do the old, what does the Department of Mental Health have to say on that? Do y'all have
Sure.
and I think what Senator Hobson is bringing up is that, yeah. And this is Bo Chastain and Dr.
Tom Recor, Dr. Tom Recor. Our concern is with the language that's on line 24. And we feel like that change in language is going to allow individuals who are charged with felonies to be civilly committed to a.
Yeah, and the Senate proposal is to put that language back. But Senator Hobson is asking about whether the circuit courts are trained to do that. And I guess maybe this is a good question for the doctor.
Senator Hobson, in particular, what this bill does is it allows circuit judges to civilly commit individuals who have been found not competent and not restorable to proceed. And usually the way that works is if an individual's not restorable on a murder charge, for example, not competent, and then is sent for treatment, and no matter what we do, they can't be restored to competence. The charge is remanded and the case is sent to Chancery Court, where the chancellor is going to have a much less understanding of the details of the specific incident or the relevant mental health issues. And so what we see is the circuit will remand the charge. The chancellor gets it. There's some question about what they're supposed to do with it. The person waits in jail for months or years. And if the circuit judges had the opportunity or had the ability to go ahead with the civil commitment, specifically in those cases where a person's not restorable, then it would expedite the process of getting that person out of the jail and into treatment when there's no way for them to be adjudicated.
Maybe, Mr. Chairman. Look, I'm not an expert and I don't do criminal work, and I really am not, I'm more tangentially involved with some commitment process. But I know traditionally our chancery courts have done commitment processes, not our circuit courts.
Right.
And so would there be any due process issues for the proposed, for the accused or the proposed committed person? What are the due process procedures in the circuit court, and how do those differ from the chancery court procedures?
So people that are committed to Mississippi State Hospital under the circuit court's jurisdiction is for the purpose of competence restoration. That's why they would be sent for treatment at the state hospital. If that treatment isn't successful, let's just say it's on a murder charge, for example, then the person's charges go away and they're civilly committed. Okay.
If I may help there,
Yes.
if that's the case, rather than they go away because they're incompetent to stand trial.
Because they're incompetent and we offer an opinion that they're not restorable to competence.
Not restorable to competency, so therefore you can't prosecute them criminally.
Correct.
Therefore, then they go into a forensic,
Then they go to civil commitment.
you go to civil.
So they've already been sent for restoration. That fails. If that fails, then they're sent for civil commitment. And what this bill would do that the Department of Mental Health really agrees with is give the judges the choice to go ahead and do the civil commitment on their own without having to send it to Chancery and wait for that whole process. So the due process issue is something that the circuit judges aren't used to doing would be a dangerousness assessment, would be determining, is this person dangerous to themselves or others based on the available information, which is something we include in our reports of non-restorability. And this bill allows them to use that report.
By way of clarification, because right now, so they're waiting if they're in the circuit system, they're waiting for the chancery process to take place, which means that they have pending criminal charges, which means that they're either in the jails with other folks and all of that. And then that goes through so there's a whole lag time. Am I correct in that?
That's right, Mr. Chairman.
Okay, and so by allowing the circuit court to do it basically from the time they're charged, but even indictment, they can begin that process, which would significantly reduce some of the time. Is that correct?
Once the person's been found not restorable to competence by the circuit court, they could proceed with their own civil commitment proceedings in that particular instance.
May I ask
Mhm.
just another question?
Yeah.
What's the difference between the civil commitment and the criminal commitment? You were explaining that, but I just didn't catch it.
One of the reasons so if a person's facing a felony charge and they don't have the ability to work with their lawyer, then they can be referred to the state hospital to be restored to competence. So an evaluation is complete. An opinion is offered by a certified evaluator that a person's not competent to proceed. A circuit judge can then send them for restoration to competence so they can exercise their Sixth Amendment.
Is that considered criminal contempt commitment?
It is. It's a criminal commitment.
Okay, and the civil commitment is what?
So the standard for civil commitment is dangerous to self or others plus mental illness. And it's for the reason that the person's dangerous to themselves or others. And part of the argument, when I go talk to the circuit judges, I usually talk to them about twice a year. And they accurately identify that they are much more familiar with the issues brought up in the case than a chancellor could be, given the amount of time they've spent on the particular case.
It seems to me that it's less important about the issues in the case than it is what the mental state is of the person. Am I inaccurate? in that?
No, you're accurate. It's just that sometimes clinicians think about risk of dangerousness differently. So for example, if a person was civilly committed, but they had committed a murder in the last year, but they're stable in the hospital, then under a chancery commitment, you could make an argument as a clinician that this person's safe to go. And so with a circuit court order of commitment, this is identifying that there are chronic risk factors that have to be considered. And so it allows the circuit judges to act on that.
Thank you, Mr. Chairman. I confess that I don't know quite enough. I just know that this was sent the other way some years ago for the very reason that chancery courts would be better equipped to be able to handle the commitment process. And no offense to anyone, but it just, as I recall, that's what was done here. And I would just say we need to tread carefully when proceeding here, because we want to make sure that everybody, that the justice system is properly done. Not that I don't have confidence in circuit courts to be able to handle certain things, but they're not seeing commitments regularly like our chancellors are. And I'd say food for thought as we go through the process in dealing with this. So thank you, Mr. Chairman.
I certainly will say that if you can find time in your busy schedule, that the good doctor will explain. We sat down, and I'm probably not doing the best job, but he's very equipped at talking about that. So I think, Senator Branning.
Thank you, Mr. Chairman. Just a follow-up from Senator Hobson's questions there, the difference between the civil and the criminal commitment. I'm looking on lines 29 through 39, and it talks a lot in this particular paragraph about the civil commitment procedures. And I just want to make sure that if the intent
Of
is
the
to,
strike all or the regular bill?
oh, forgive me, I may be looking at just the bill. Let me make sure that I'm looking at the right. So in the strike all, it will be line 29 through 39. I just want to make sure that we are, on line 30 in particular, it talks about the civil commitment procedures. I just want to make sure that if the intent of the strike all is to transfer the ability for circuit court to handle criminal commitments, that is in fact what we're doing. It looks to me like we may be dealing with civil commitments as well. And I think maybe I'm asking for some clarification.
Well, okay, so the language you're looking at in in 2930. That's the House bill language. Okay, that's what came to us. And yes, this bill is giving the circuit court that civil commitment jurisdiction. I think a way to maybe look at this is when we had the hearing on public health.
Not restorable. In other words, no matter what we do with that person, they can never be adjudicated for the alleged offense because no matter what we do, they're not restorable. So it's only in that particular instance. This doesn't open it up with the current language as amended. This doesn't open things up for circuit judges to just be civilly committing folks. It's only in that particular instance.
And I guess my follow-up question to that is sections 41, 21, 61 through 107. And I don't have the code in front of me, but if just memory serves from times past, having handled a few of these, I just want to make sure that we are not opening this up to all other types of commitments and that we're just keeping it limited to the criminal commitments that have been described. By the way, I'm supportive of that for the criminal commitments, but maybe council's looking at me saying that's correct, but. Okay. Thank you, Mr. Chairman.
Any other questions? Senator Barrett?
Thank you, Mr. Chairman. I've had a few of these in practice, and what I have seen is if someone is unrestorable, we'll have our competency hearing in circuit court, and the state hospital final recommendation may or may not be they need to be committed civilly. And I know that's what we're talking about here. I guess my question is, further down the line, in the past, if this person was committed civilly and the special master, maybe in Chancery Court, feels this person needs outpatient treatment, let's just say. I guess your point is a circuit court judge may be better in tune to know what treatment or what kind of help this person would need. Is that what the purpose of this is?
Fundamentally, the way we approach this particular issue is if a person is not restorable on breaking into their neighbor's shed and stealing an old microwave, they can probably go to civil commitment as usual, and they don't have to wait in jail forever for it to be transferred to Chancery Court. There's so many different ways that can get lost. The circuit judge can do that right away. And then for someone who's not restorable on a serious charge, that person would go to a long-term forensic bed, even under just a civil commitment. This expedites the process and has people not languishing in jail for years in that limbo space.
Okay, and I'm sorry, I came in a little late. So in this hypothetical, the Mississippi State Hospital says this person is unrestorable.
Yes.
We have the competency hearing in circuit court. And is it the purpose of this bill to have the commitment at that point, or will there have to be another filing in circuit court on a civil? It can be handled as part of the criminal action.
This gives the judge the ability to do that, yes.
Okay, thank you.
Thank you for that question, which is the point about speeding this along and doing that. So, all right, any other questions? All right, I have a motion to adopt the strike all. Have the motion to adopt the strike all in favor say aye. All opposed, that carries. All right, we're on, thank you, title sufficient, do pass, strike all in favor. All opposed, that carries. The motion was made, I saw that. Thank you. Okay, thank you for the good discussion on that one. Thank y'all for that. I'll get with y'all too before it comes up on the floor. Thank you. All right, House Bill 1102. This is the same one that we passed for DHS. You have before you the proposed strike all, which is simply putting the bill that passed the Senate into the House bill. And that was the bill that, if you recall, DHS wanted to be able to work with the financial institutions to provide notice when they had to do that. So with that, I have a motion to adopt the strike all. The motion is to adopt the strike all. All in favor say aye. All opposed? Okay. Motion is title sufficient, do pass strike all in favor? Aye. I'm gonna pass over the next one and go to House Bill 1607. That is, so I'm going to ask you to not consider the proposed strike all that's in your packet. The reason for that is that if you recall, we passed the SAFER Act, which was Senator Chairman Harkin's bill. We passed that off the floor, passed overwhelmingly. This bill, the House bill is before us, it's not the same version, but it's in the same space. Okay. So having talked with the House chairman, what the motion is that we take the Senate bill that we passed, Senator Harkin's, as the strike all with this bill. The proposed this before you simply only has a reverse repealer, but having had conversations as recently as this afternoon, that's what we'd like to do. So if somebody would like to make the motion, which is that we take the SAFER Act as a strike all and amend it to this. So Senator Boyd, I see that motion. So any questions on the motion? All in favor, say aye. All opposed? Okay, thank you on that one. And so then we need to vote on that. So all in favor of title sufficient do pass as amended, all in favor? All opposed? Ayes have it. Thank you very much. All right, House Bill 783. That one. We had I don't see Senator Hickman. So we had a similar bill. I've had discussions with the authors here as well as the chairman. What you have before you again is a proposed strike all. And for those that if you look at on the regular bill or on the bill, if you look at lines 36 to 44, that's what they are attempting to do, which is to have a rebuttable presumption of joint custody. Now, in talking with the authors of the bill and talking with different ones, part of the issue is within our state is the fathers are being, some would argue, prejudiced, even though the law says that's not the case, that's what it should be. So if you look at the proposed committee substitute, if you look at lines 46 to 52, that's the proposed committee substitute language that says whether after trial on the merits or a presentation of an agreement between the parties, the court shall make a finding on the record if the court awards paramount physical custody over the father, and the court shall order a parenting time schedule that favors both parents equally subject to the best interests of the child. It's a little bit different wording. The House bill had a rebuttable presumption, but we're trying to get to the point where parents are being handled equally on a parenting schedule. So that may be a little technical, but I'll open it up to questions. Any questions? Senator Boyd?
Can you tell me who has brought forth this legislation, feeling that this is a this is a significant issue in our courts right now.
Yeah, so it's Representative Shane Aguirre. And you see that he contacted me, I've talked to him. I went over my things about it. And I've had other people, just really individuals, talking about how current law is being handled. And so, but he's brought it forward.
Okay, and so when the task force, I know we convened on a number of things 2 years ago. Did this ever get brought up in the task force or anything like that as this being an issue that needed to be addressed?
I don't recall.
Okay,
What was made clear to me was there are places where fathers are being, again, prejudiced, or certainly seems that way, even though the law says that. And I will tell you, the rebuttable presumption in the House bill, I thought personally went a little far, which is why we have the proposed committee substitute.
have we haven't added anything in this legislation, have we?
What do you mean added?
Like, the Senate we haven't made any amendments to this as it came over from the House yet, have
No,
we?
just this proposed strike all that's before you.
Okay. Thank you.
Any other questions? Senator Hobson?
Thank you, Mr. Chairman. Does this do anything to affect the tender years issue that the courts looked at? And
No.
you don't think it would affect that maybe when they're infants, that
Hmm.
that could be
I see what
utilized?
you're saying. I guess what I'm sorry, when you were saying tender years, I guess
Well,
that
let
was
me give another example that if
an
you're-
infant,
What's that?
an infant.
Yeah, if you had an infant
Right.
and the mother was breastfeeding the infant, would there be, maybe that's a rebuttable presumption, but I'm just thinking of maybe certain
Well-
cases where it may be better for one parent or the other. And I don't think this would affect anything. Answer that first, and I'll ask the next question.
Well, I think that's actually proves the point I was trying to make earlier, which is, and which one, if you have as the House, you have a rebuttable presumption, I think that's difficult, or your point is well taken, that if you have an infant, I mean, that's, and the mother's breastfeeding, usually most chancellors I know award the mother because of that. But if you look at the proposed committee sub, it says if it's an agreement or a trial on the merits, and as long as the court puts it on the record, I think that certainly would be a reason why the court could award that. So it's a child of, 6 months old and breastfeeding, and so needs to be with the mother. I think that's certainly going to be, whereas if it was a rebuttable presumption, it's already saying it's got to go with or I guess that wouldn't be the case.
What about the 12-year-old selection? Does that affect that at all?
I don't think it does. As you know, a 12-year-old, while they don't get to dictate, they certainly can give their preference. Again, if the court does award the mother, then all they have to state is put it on the record as to why that was the case. And then it being on the record, if the father or the opposing side wants to appeal it, it's on the record, and all the other various Albright factors and everything else that goes into that can be looked at.
Is this something that the chancellors have weighed in on? I mean, they're the ones that hear most of the domestic cases. Have they commented on this at all? I'm curious.
I have
Not
not
that we
heard.
have to listen to the chancellors all the time. No offense to our
Right.
friends on the chancery bench, but
I have not heard anything from any of the chancellors, no.
okay. All right. Thank you, Mr. Chairman.
Senator Branning?
Thank you, Mr. Chairman. Is the language that begins on line 291 that talks about the 13th ground for divorce, is that the same language that we have seen before in the Senate?
Yes.
Okay, thank you.
Okay. So have a motion to adopt the strike all? The motion's to adopt the strike all. All in favor, say aye. All opposed? Motion carries. All right, have a motion, title sufficient, do pass, strike all. Have the motion. All in favor, say aye. All opposed? That carries. Thank you. That discussion. All right. I don't see Senator Thompson. We will call up. I'll tell you what, I want to go to House Bill 1343 first. And I will let Senator McCon explain that one. If you're willing. Oh, I'm sorry. I apologize. Nope, you're right. It wasn't. 1343 Scrivener's error. Get to that. Why can't I got it. You look at lines 40. Just in general terms, if you know Scrivener's error, if it tends to be a technical change, and what this is doing, lines 40 to 44 are the optimum changes to the current law. If the affiant was in good standing with the Mississippi Bar, was licensed to practice law when the document was recorded, and was retired from the practice of law at the time of verification or affirmation. It simply allows the Scrivener's error to be corrected by an affidavit. Any question? Motion's title sufficient, do pass. All in favor, say aye. All opposed? All right, go back up to House Bill 413. And the optimum language is lines 207 and 213. And this is from Representative Sanford. So it's simply allowing for the damages where there's killing or chaining a dog is authorized by Section 1 of the Act. Is adding that into the I think let's see, to the dog bite or the sorry, Senator
I'll
Hobson.
wait for you to finish.
Yeah. Go ahead.
I do, yeah. Well, it looks like it's adding a whole new section of law here. As far as the part in 212, I don't know that concerns me, but if this is indicating, which I think it is, that the court, you're creating a new law that says the court creates these certain remedies for the dog bites. Am I correct? Isn't Section 1 new law?
Yes, that's correct.
And are the court's not allowed to be able to order payment of expenses for dog bites right now?
I'm not aware of that, no.
I think they do have that.
But you're
ability.
right that Section 1 is the new section. And in my brief interaction with Senator Thompson on this, that the intent was to add damages in where that occurs.
I think they're allowed that right already. But it says regardless of propensity of the dog. That may be the catch, but I do have concerns about that, because if you've got a dog that's never had a problem and somebody agitates to the dog to the point that it bites the person, you can have them order. Typically, it's the one bite rule or the dangerous propensity. So we're saying now that you don't even have to have that.
Yes.
Well, I just think the case law is sufficient enough to cover this as it is. There are plenty of cases on this, I believe. I've actually tried a case on dog bite. So somewhat familiar with this, but I just don't know that we need to create statutory law on what the court should determine in creating remedies for dog bites.
I mean, the chair would entertain a particular motion.
I'll move to table.
Motion is to table the bill. All in favor, say aye. All opposed? Okay. Thank you, Senator Hobson. I want to go down to House Bill 325 and turn that over to Senator McCon.
And this is a bill that we've seen in the past, and I would like to bring it through the committee for discussion before it goes any further to the floor. This is Representative Sanford's bill on right of first refusal. Last year, this got kind of convoluted on the floor. He's assured me this is supposed to be as straightforward as it can be, and that he wants to be sure and clear up that a right of first refusal on real property will expire upon the death of the grantee unless there's a contractual language on the instrument's face or conveyance or a memorandum of the contractual agreement that says otherwise. Basically, he wants to clear up the language. It says, from this point forward, if I reserve a right of first refusal, then it belongs to me. Doesn't belong to my heirs, doesn't belong to anybody else. But if I reserve a right of first refusal unto myself and to my heirs, then it will go to the heirs therein. Now that's the simple language that he's wanting to bring forward. And I do agree that there is some ambiguity out there on some instruments. But at the end of the day, this would protect some of those in the future that do not properly put in the language as they should. But I think it's very well a step in the right direction. I would entertain questions on that. If not, I would have a motion.
Motion is title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? That carries. Thank you very much. House Bill 846, that is the companion bill to the one that we've already passed, Senator Kirby's bill, where the fees were raised, charged by chancery clerks. I would ask if we could just, there's no changes or no difference between the two bills. We just want to have them both there, and I'll work with the chairman on that.
So moved. Title sufficient, do pass.
Motion's title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? That carries. House Bill 1086. You look at, I don't know how many people have dealt with partitions, but this is what this is concerning. If you look at lines 38 to 44, that's the language that's being either changed or updated. And it's granting the court the power to order another person on the land to leave the land. And then states, if you look at line 41, any person that fails to leave, the court may order the sheriff. You would think that wasn't there, but it tends to be a problem, I guess. Senator McCon, you have anything to say on that?
I think one more thing to put in there is that, just to clear it up just a little bit, is that if there's a tenant on the property and there's a partition action, there was no previous ability for an ejectment. This allows that to be pled in the same petition. And then additionally allows for, I believe in the past, when this partition action was passed our first year, it's a petition of heirs in which they're talking about, that this allows for now the individual to pursue either partition of heirs or the regular partition actions that we've got out there. So that was the goal in this piece of legislation. I see Senator Hobson.
Yeah, Senator Hobson, you have a question?
Thank you, Mr. Chairman. One technical correction possibly is on line 40 and 41, when they are ordered to leave the land and remove only his or her own property from the land. I've got to assume that means personal property.
That'd be correct.
Because
So-
if you've got a house or something that's attached, a pertinent, fixture, that couldn't be removed. You couldn't tear down the house when you were leaving, I assume.
And I agree, because that, I would entertain that motion.
I'll move to amend to include personal in front of property.
Okay, the motion is, you got that, Ethan? The motion is to
And
add
that-
the word
Mis-
personal.
Mr. Chair, yeah, I
Yeah.
think that's looking, I'm just scanning through it. It looks like that's also in line 111 too. That's the motion.
So the motion is to add personal to it and conform the bill to that. So that's the motion. Any questions on that one? All in favor, say aye.
Aye.
All opposed? Okay, the amendment carries. So we're on the bill as amended. Have a motion.
How does fish do pass? Committee sub?
Mo-
Amended, whatever.
Motion is title sufficient, do pass, committee substitute. All in favor, say aye. All opposed? That carries. All right, and the last bill for today, House Bill 1284. I'll let Senator McCon describe that one, which is, we've already done our version.
We have done our version and, Mr. Chairman, I would entertain a strike all amendment on this to bring our language in here. The only changes in our language and their language is, I think there's the word industrial in there at one point, which raised a few eyebrows by some of our folks. So we want to put our language in there just so that it conforms both of them to the same one. So I would have an amendment of the strike all for our language.
The motion is to, with a strike all amendment to add our bill to House Bill 1284. Any questions on that? All in favor, say aye.
Aye.
All opposed? That carries.
Title sufficient do pass strike all.
Motion is title sufficient, do pass, strike all. All in favor?
Aye.
All opposed? And that carries. Okay, that's, we will meet tomorrow at our standing meeting, which is 2:00, room 409. So have a motion to rise and report. Thank you very much.